Hi, everyone. I think we're going to get started.
Please take a seat.
About 2/3 of the faculty members in the room apparently have to go teach a class, well, different classes, at about 1:30. So we're going to get going pretty quickly. And for those of you who don't have somewhere to be at 1:30, this is not some sort of organized protest, I hope, against what I'm going to talk about.
So let me just welcome you, Dan. This is the first business law workshop this term. We have as internal speakers today Professor Dan Awrey speaking about derivatives Deconstructed, and we're very much looking forward to our presentation and the discussion.
All right, our first challenge of the day is moving the cursor. So thanks everybody for coming today. This is a bit of a strange project that I'm going to present today. I'm not entirely sure what it is, whether it's a paper, whether it's a book, whether it's a teaching aid, or whether I'm actually trying to say something that might be a little more profound. Chances are that I'm not, but I don't know for sure just yet. The reason that I originally embarked on this project was I was still a little disappointed with many academic treatments of how derivatives actually work. Depending on the type of textbook or type of article we're talking about, we see vastly different presentations about what derivatives are. One based on derivatives are kind of like equity securities in that they trade in deep and liquid markets, the sort of arm's length finance view of the world. And one that views them quite squarely as executory debt contracts that may have equity-like features attached to them. So one an equity-based world, public equity-based world at that, and one a more debt-based world. How I'm attempting to make sense of that in this paper is that especially when things are going well, given some trends I'm going to talk about today, derivatives do often have many of the same characteristics as highly liquid equity or debt securities, so shares or bonds. But when things go bad, and I'll talk about the difference between good and bad a little later on, we start to see the debt-based elements of derivatives come to the fore. And that all of this has a number of enormous policy implications in terms of both how we treat derivatives, but also in understanding the social desirability of good time derivatives versus bad time derivatives, and whether we think we need to do something about that. So the conceit at the heart of this paper at the moment is that one of the ways that we can understand this sort of distinction between good times and bad times is by dividing derivatives up into their constituent elements and then seeing how these different elements interact with one another. And I'll go into all of this in a bit greater detail. I'll come back to this setup at the end, but it's useful, I think, to have this in your mind as we go through. So I'm creating my own periodic table of derivatives elements, in effect. And the first thing we're going to talk about today is contract. And derivatives exhibit some of the most sophisticated state contingent contracting in the financial world, relating to things like basic payment and delivery obligations, collateral requirements, and closeout and payment netting. What we also see is the extensive use of property rights, however, and specifically in relation to the collateral that's posted against the obligations, the contractual obligations used in derivatives markets. And then, and this is where we sort of see a shift in derivatives, we also see some pretty extensive non-contractual, non-property, non-legal mechanisms used in these markets. This observation goes back to a couple of things. First, my own experience working in these markets, but more importantly, my conversations over the years with derivatives traders, derivatives lawyers, at the height of the financial crisis, where what we saw was very little formal enforcement of contracts, even when they were out of the money, because of the reputational constraints that were created out of the expectation of future dealings. We're all going to come out of this crisis someday, and that litigating to get a short-term gain now could have longer-term reputational effects if we become, or if we get a reputation as a litigious counterparty when the system is at stake. And so one of the things that I'm trying to grapple with in this paper then is understanding when we see contract and property dominate and when we see reputation and the expectation of future dealings. These informal mechanisms dominate in the context of binding counterparties to derivatives. There's another element here. This is actually something that is fairly well documented in the literature, is that a lot of the way that the contract and property rights work, specifically around collateral and closeout netting, rely on extensive legislative regimes that exempt the operation of these mechanics from applicable corporate bankruptcy law. I've grayed that out because I'm not going to talk about it too much today, except to point out the bits of derivatives contracts where it's immediately relevant. And what I'm going to suggest to you guys is that we can see a pattern, a general pattern, not followed in every case, but a general pattern of where each of these elements, if you will, bind. And on the left-hand side, we have states of the world where nothing happens. So we see no observable changes in market or counterparty credit risk. And there, all the contract really does is provide a blueprint for what obligations are supposed to be performed and when. As we move into observable changes in market and counterparty credit risk, the contract also has things to say there. But we also start to see the importance of property rights playing a role in insulating parties from risks, specifically in the form of initial and variation margin. Then we enter the interesting stuff, where we start to see non-observable changes in market and counterparty credit risk, or we start to see more fundamental uncertainty or instability in the marketplace. Here's where relationships and the expectation of future dealings can actually play a role. And this role can be a double-edged sword. So it can provide parties with flexibility to overcome problems that arise as a result of this uncertainty, or it can become the thing that, when it breaks down, actually becomes the trigger for financial instability. Why? Because once relationships become important to holding a relationship together, when it falls apart, we find ourselves in a position where parties face their own solvency constraints, and there we start to see the breakdown of these markets. So on the left-hand side, we can think of this as being effectively arm's-length financing. On the right-hand side, we start to see more relational financing, and then once we get to a critical mass, and I'm not sure where this is, once we get to this critical point where markets start to break down, all of a sudden we see binding legal constraints start to play an important role again, especially at the point where derivatives counterparties encounter insolvency. All right, so I want to briefly start out with what I think is the anatomy of a derivative contract. For those of you who have read some of my other stuff, I apologize for being slightly repetitive. Again, I'm a little bit dissatisfied with a lot of the academic literature and understanding what derivatives are and what they're really trying to do. I'm talking about a diverse range of instruments, all of which historically would have been called over-the-counter derivatives. So these, I dislike the name, but there you have it. The defining feature of these agreements is that they're not exchange-traded futures. As we'll see, exchange-traded futures actually exist at the far one end of the spectrum of derivative contracts, where through the process of exchange trading and clearing, you've completely eliminated the relational aspects of derivatives contracts. So you've got the fully commodified version of derivatives contracts. I'm dealing with contracts that are bilateral contracts. They are, at least in some ways, bespoke, even if it's just the identity of the counterparties to the contracts. And they take all these various different forms. And don't worry, we won't actually go into all of them. Now, what I think are the most important aspects in terms of understanding what the risks are in a derivative contract really come down to two things. The first is market risk. So what I've got here is just a plain vanilla interest rate swap. For those of you who are maybe less familiar with derivatives, I've got two counterparties, counterparty A and B. And the essence of their swap contract is that one agrees to pay a fixed rate every given period, so in this case, every 6 months for 5 years. And the other one agrees to pay a floating rate. And then every 6 months, they calculate both rates. Obviously, the fixed rate is the fixed rate. They calculate the floating rate, they net out the two, and one party owes the other money. You could also have derivatives that are physically settled using some sort of commodity or instrument, but I'm going to abstract away from that for the moment. And simply note that in this particular example, so fluctuations in the rate of the London Interbank Offered Rate, or LIBOR, is the representation of market risk. So the fluctuation of some sort of variable or underlying asset up or down. Volatility, in effect, is the essence of market risk. And as we'll come on to in a moment, market risk is ultimately what you're trying to take in the context of a derivative. However, there's another risk, and I think a far more important one in understanding the structure of derivatives contracts themselves. And that's the fact that if I promise to do something semi-annually over a period of 5 years, my counterparty is vulnerable to the risk that I'm unable to do that. So in effect, I'm taking on counterparty credit risk that whatever contractual obligations my counterparty takes on will be performed in due course. This is obviously a function of time. Spot contracts don't have this feature. Equity securities, bond trades also don't have this feature insofar as there's only a very brief period between the execution of a trade and settlement. This is a debt-specific and an executory debt-specific type of feature. And as we'll come on to, is really responsible for 95% of the mechanics underpinning derivatives contracts. So the takeaways that I'd like everybody to take away from this are first that there's this distinction between market and counterparty credit risk, and it is unique. So a question that I get asked all the time, well, what about a bond, right? Doesn't a bond have both market risk and credit risk attached to it? Absolutely right, but they're completely identical in that particular case. The market price will reflect credit risk, and there's no way of separating them other than actually creating a derivative contract that is designed to separate them out into their constituent elements. In a derivative, market and counterparty credit risk ideally are perfectly uncorrelated, and unless you enter into a derivative agreement with your counterparty that ensures you against that counterparty's default, they will be separated to some certain degree. And the important thing here is that you can be perfectly in the money from a market risk perspective, but your counterparty fails and now you're out of the money. So the contract says you win, bankruptcy says you lose. And so there's this distinction and a tension between market and counterparty credit risk that I think makes derivatives different, at least derivatives broadly defined different, than most other financial instruments. The second thing is that nobody really wants counterparty credit risk, right? There's quite a bit of academic literature out there that says people want to take on counterparty credit risk. Outside certain regulatory capital arbitrage scenarios, I think it's pretty safe to say that counterparty credit risk is just the evil byproduct of using derivatives to take on some sort of market risk. Again, this is pretty important, and I think what evidences this most of all is that what I'm going to talk about next are going to be all the different ways that derivatives contracts attempt to eliminate counterparty credit risk in order to make the play on market risk as pure as possible. And the last thing I want to point out is that derivatives are debt. These are executory debt contracts that have future IOUs attached to them. And so in the process of sort of understanding what the regulatory implications of the widespread use of derivatives are, it may not be just issues about market transparency, a la equity markets that we're interested in. It may not be sort of dedicating the regulation of derivatives to securities regulators, as is largely done in the United States, that is optimal. Debt, we tend to think of something as raising prudential concerns. That is traditional bank prudential regulation concerns. And I think that's something that ultimately is important to keep in mind. Okie dokie. So this little bit is going to be a little bit for those in the room who are less sort of au fait with derivatives. But I think it's important to understand some of the basic contractual architecture before we launch into our distinction between good times and bad times. Most of this architecture, again, indeed all of the architecture that I'm going to talk about is about how the counterparties attempt to manage this counterparty credit risk. So the first thing they do is payment net. So in my original example here, I have counterparty A and counterparty B. They have one contract. I've already talked about a certain type of payment netting. That is to say that the fixed rate going to counterparty B and the floating rate going to counterparty A are often netted on effectively a single contract basis, such that only the party that is out of the money has to pay on any given settlement date. But if A and B had multiple contracts, their contracts also enable them to elect that across all of those contracts, they can globally net out. So that, and I've given an arithmetic example here, so that if you've got two contracts where each party is in the money on one contract and out of the money on another contract, I can elect that we net globally through all of those contracts and only one amount is paid. This is all done by way of contract, specifically under the ISDA Master Agreement that I'll talk a little bit about later on. The second thing that we can do is have closeout netting. So aside from payment netting, we may live in a world where our counterparty defaults. And what closeout netting enables you to do is then immediately terminate that contract, calculate, in effect, the closeout value of that contract, and then have that paid out. So depending on whether it's the non-defaulting counterparty or the defaulting counterparty that is in the money, we see a contractual rule that in effect tells you who gets paid, how, and when. This, as I said, is contract. It's also, though, and here's the first point where legislation comes into it, you might think to yourself, geez, so a party defaults, maybe it goes bankrupt, and all of a sudden my derivatives counterparties are able to terminate that contract immediately, calculate an amount owing, and have that paid. That sounds like on its face like it violates certain process rules in insolvency law, namely the automatic stay and fraudulent preference rules. In countries like the UK, indeed jurisdictions like the European Union, what you see are very bespoke legislative regimes that are designed to carve out these specific mechanisms from the application of those rules. So in this case, we see contract supplemented by legislation that gives effect to those contracts. And then the third mechanism, and one that we're going to spend a lot of time on today, is collateral. There are two types of collateral in derivatives markets. The first is initial margin. This is a space that contractually is evolving quite rapidly. A generation ago, and a derivative generation, which I suppose is less than a human generation ago, initial margin was just about the risk of counterparty default. So if Horst and I entered into a derivative contract, initial margin would reflect the probability that either Horst or I would fail. So it would be static and set at the outset of the contract. In the wake of the financial crisis, however, a lot of initial margin terms now have a variable in them that's reflected in changes under Basel III capital requirements that say that, well, no, we're going to monitor Horst and I's credibility or probability of default over time, and we're going to adjust this initial margin periodically in order to account for those changes. And we can talk quite a bit about that, actually, if people have questions later on in terms of what precipitated that change in methodology. But the basic idea is that this initial margin, or the initial amount as it's termed under the contracts, is generally thought of as designed as a response to counterparty credit risk. The second type of margin that we have is variation margin. And here we have a very specific focus on changes in market risk. So in between settlement dates, obviously, the price of the underlying asset can fluctuate up and down. And the parties can insulate themselves against those fluctuations by having variation margin applied on a periodic basis. So they can do it, if they like, every 3 months. They can do it every 24 hours. Really, in this bilateral world, there's no limit on the extent to which the terms of this variation margin can vary, both in terms of timing, but also in terms of the amount of collateral, how it's calculated, and things like that. But the key for our purposes, putting aside all the technical details, is that this collateral, both initial and variation margin, is a hybrid creature of both contract and property. So it's contractual always in the sense that it is contract that then contemplates when property rights will need to be transferred under a derivative agreement to secure either counterparty credit risk exposures or market risk exposures. And then in some jurisdictions, depending on the type of security interest system, or sorry, the type of, in effect, property transfer system that you have, whether it's one based on exchanging property or exchanging security rights in property, we see this attempt to make everything as self-executing as possible, again, using legislative regimes. So if I use property, for example, if I say to Horst, OK, you are out of the money on this contract, and I want you to transfer me collateral. I take ownership of the collateral at that point, and I have the property rights in it and can sell it, do whatever I want with it. Under some regimes, however, how it would be done would be that Horst would grant me a security interest in that collateral, but Horst would still own and have possession of the collateral. What legislation does in that case is that if Horst goes bankrupt, again, procedural laws under bankruptcy law apply, and under normal circumstances, I couldn't then go out and enforce my security interest and get that collateral back. So we see legislative regimes that are designed to enable me to do that, to treat that contract right and security interest combination in effect as a form of property. All right, so that's the basic makeup, what I've called the anatomy of a derivative contract, mostly based on understanding counterparty credit risk and the various responses to it, designed to illustrate both the distinction between market and counterparty credit risk, but more importantly, that these contractual mechanisms also contain elements of property, legislative regimes in them, and start to look more like executory debt contracts than anything that we might see in the world of shares or bonds. Now, the next thing I want to do is talk about how all of this plays out under different market scenarios. For those of you that read the paper, you'll see that this is still a work in progress, as denoted by the fact that I've stuck my definition of good time and bad times in an appendix, because I can't really figure out where it goes yet in this paper. Shorthand, however, good times are where market prices are observable, where changes in the price of the underlying and in counterparty credit risk are observable, either through changes in market price in the case of the underlying, or things like changes in credit rating or other proxies for counterparty credit risk. And bad times are really the opposite of that, effectively, where we start to see information problems in markets and they begin to break down. So let's look a little bit about derivatives in good times, and specifically how things have changed over the last 20 or 30 years that have, I think, framed this idea that derivatives markets are becoming increasingly more like arm's length financing and less like loans or other executory debt contracts. I'm going to look at three different sort of facets of this. First, the basic payment and delivery obligations, and then two things we've talked about a bit already, these collateral support arrangements, so the process by which collateral is transferred between counterparties and closeout netting. So the first thing that we've seen is the standardization of the basic terms of these contracts under the auspices of the International Swaps and Derivatives Association. So we see the ISDA master agreements in all their various guises for different types of derivatives, being by far the most dominant contract form. Estimates are a bit dodgy, but about 90% of the market, if not more, are documented in ISDA agreements. The contractual structure is interesting and feeds into this idea that these things are becoming increasingly commodified. So we have, for the most part, under these agreements, a very basic modus ponens if-then structure, right? Like, it's the economist's dream of classic state contingent contracting. If LIBOR interest rates are above X, then Y party will have to pay Z party a given amount. This is also supplemented by what I would call sort of over time contractual learning about various scenarios that arise that initially were not dealt with in the contract, but become embedded in the contract as a result of disputes that have arisen. Some of the best examples of this are often things like freezing assets as a result of orders in a jurisdiction. So the United States freezing Libyan assets and Iranian assets have given rise alone to a wealth of case law dealing with, well, what the heck happens when the government intervenes and all of a sudden I can't get access to my cash, I can't pay you in the normal course of business under this derivative contract. And what you see then are detailed terms that are designed to dictate what happens in exactly that scenario. So we see the gradual, this incremental sort of increase in the number of state contingent terms as we learn through case law about what can go wrong and enable the parties then to deal with that through state contingent contracting. And again, if you look through the history of this, the two big problems that arise, and this is now reflected in the contractual architecture, are capital controls or asset freezes, and also physical delivery problems. So Our modern world of financial derivatives was preceded by a world in which physical delivery of underlying commodities was often an important part of what derivatives did. And you see then very detailed contractual terms arising around, for example, the quality of delivery of grain, onions, things like that, where they have particular storage problems, where there are problems of quality that might arise. And you see very detailed contracting around things like, well, you can deliver 100 units of grade A grain, but if you can't get your hands on 100 units of grade A grain, you can deliver 125 units of grade B grain, and so on and so on and so forth, designed in effect to encapsulate as many circumstances as it possibly can. Next, I won't go into too much detail here except to say that there's also quite a bit of state contingent contracting governing the circumstances where parties will be required to post collateral. This includes both the basic initial and variation margin requirements, but also things around how to calculate what those margin requirements are at any given point in time. And as we'll see later on, this is one area where it's actually quite possible to find yourself in a world where it's difficult to use detailed state contingent contracting ex ante in order to resolve these problems. Specifically, what happens if you don't have a market price and you have to calculate collateral requirements? And we'll talk about that a little bit later on. Lastly, we have closeout netting. And here, if there are any derivatives lawyers in the room, you can feel my pain. Here is where lawyers really get into the nitty-gritty of all the various things that can go wrong that lead to either a termination event under a derivative agreement, effectively an event where nobody's to blame, but we still want to terminate the agreement, or an event of default, which is effectively where there's been a material change in one party's ability to perform its obligations. And just to give you a flavor of this, this is section 5A7 of the 2002 ISDA Master Agreement. This is the definition of bankruptcy for the purposes of the ISDA Master Agreement. It has, I think, 15 separate heads that define what a bankruptcy event is. And even then, it's still one of the most litigated provisions in all of derivatives agreements. So we see incredibly detailed contracting. At the same time, we still see enough incomplete contracting that there is litigation designed to clarify these terms. All right. This standardization, this incremental growth of state contingent contracting added to then the standardization under the auspices of ISDA has facilitated a good deal of automation in derivatives markets. I don't have a lot of time to go here what sort of precipitated this. The last time I was in derivatives markets, most of this was manually done. So you would get a fax from your counterparty, you'd look at it, and your compliance officer would sign off on whether it had the right terms and fax it back. When you're talking about several thousand agreements a month, that becomes a pretty big headache quite quickly. And in fact, this came to a head in about 2004, 2005 with credit derivatives, as a result of which the Federal Reserve Bank of New York, I suppose, spearheaded an initiative designed to overcome this paper processing problem, with the result that we see an increasing proportion of derivatives cleared and settled through automated processes. Unfortunately, this is some data that I've collected on the basis of BIS and ISDA surveys. Unfortunately, of course, because the problem only really came to a head in 2005, detailed statistics only started in 2006. What you would see, and unfortunately you have to take my word for it, if you could go 5 years back in time on this chart, would be somewhere definitely south of 20 and probably pretty close to 0. And what was above 0 would just be the industry leaders at the time starting to implement automated processes while most of the marketplace was still not automated. And even then, really only with the most popular liquid products, so things like forward rate agreements and interest rate swaps. So we've seen, and the red line is the important one here, we've seen an increase from about 55% in 2006 to about 77, 78%, so about a 50% increase in automation over the course, effectively, of the last decade. Yeah?
Can you explain why around 2008, 2009 there's this drop? Is that related to your good and bad times, you think?
No, I don't have a theory for that at all, to be honest. Yeah. I mean, the data doesn't really give you too much of an insight into that. It's certainly possible that what happened was that compliance resources were being devoted elsewhere during this period, in effect, right? It could also be, although even then, I'm not sure that hypothesis bears out, because if you look at the Lehman bankruptcy reports, Lehman Brothers, who you might think would have been poor at derivatives risk management, actually didn't have any open positions. So these electronically confirmed and settled positions. So it was doing pretty well in this regard. Or it didn't have any, sorry, I'll be more accurate there. It probably had manual processes in place for some derivatives, but nobody challenged any of those manual processes. Yeah, it's something to think about. I haven't really put too much thought into it at all. All right, the last thing, and probably the thing that everybody knows about at this point about derivatives in good times, is the shift from bilateral towards central clearing. So it used to be the case that the vast majority of derivatives existed in this dense thicket, this network of derivatives dealers and other counterparties. Everything was done on a bilateral basis, and then portfolio hedging took place at the institutional level, in effect, typically on the balance sheets of derivative dealers, investment banks primarily. And then for reasons that we'll come on to, there was this shift already taking place in many more standardized derivatives markets prior to the crisis, but incentivized even more so by the adoption of the Dodd-Frank Act, Title VII in the US, and the European Market Infrastructure Regulation in Europe, that has instigated this shift towards central clearing. Now, the reason for this is sort of twofold. The first is that by rerouting derivatives trades towards a central counterparty, you can collect a lot more data about how the markets work. So not surprisingly, the clearing mandate was accompanied by a mandate that required a lot more detailed reporting, although I certainly think not detailed enough given the prudential risks associated with derivatives, to regulators, to the CCPs, to enable them to manage risk. And then the second thing was that clearinghouses are able to coordinate then the mechanisms. So the netting arrangements, the collateral requirements, and closeout netting and other crisis management tools in the event of market disruption or institutional failure. And the reason, or the mechanisms by which they do this, are often known as a clearinghouse default waterfall. We don't really have time to go into it in any great detail today, but there are two things I want to note. The first is that all transactions of a particular type with all counterparties routed through a CCP are subject to the same rules. So you don't get bilateral bespoke negotiation. And the second thing is that in relation to things like collateral requirements, is that they strictly enforce daily or even more frequent variation margin requirements. So changes in the fluctuation of the market price of the underlying are reflected in the margin requirements very rapidly, such that, in theory at least, there shouldn't be large open exposures as a result of changes in the price of the underlying. This is then coupled then, if this is about managing risk between the CCP and a clearing member, the allocation of risk depending on which way it flows, there's also risk mutualization mechanisms in clearinghouses. Specifically, once we get to things like pre-committed insurance funds, clearing member and clearinghouse capital and contingent capital calls, and then things called position portability procedures, where effectively the clearinghouse can compel clearing members that survive the failure of another clearing member to take on the positions of the failed member. And we'll talk a little bit about that again later on. Why did I just tell you all of this? Well, when you put it all together, when you take the standardization, when you take the automation, when you take the shift towards central clearing and the standardization and automation that come with that, all of a sudden, derivatives instruments start to look more and more like liquid, standardized, highly homogeneous products. They start to look more like conventional equity and debt securities, where we can, in a sense, if we let ourselves be fooled, think that all of a sudden the only things we have to do now are make sure that people have access to price transparency and other sort of market supporting institutions. What I want to, I guess the real takeaway from today is then this trend, though true, disguises most of what happens in the way that derivatives work during bad times. And again, insofar as I've done anything so far in framing the difference between good times and bad times, I'm talking about situations where we can no longer see prices. I'm talking about situations where I start to doubt that Horst, my counterparty, is solvent. I'm talking about situations where maybe the circumstances around me are tumultuous at a market level, and I don't know where risk is going to come from. Is it going to come from the underlying assets? Is it going to come from my counterparties? Is my counterparty going to fail because of its exposures to other counterparties? These are the sorts of scenarios that both create huge information costs and uncertainty for market participants, but also become, I suppose, fertile ground for exposing how incomplete derivatives contracts actually are at the end of the day. So for all the sort of state contingent contracting that we've talked about, for all the details that have been put in the ISDA master agreement, all the jurisprudence that is then filtered into honing and revising the ISDA master agreement, there's just no way on earth that these contracts are entirely complete. We know this because we see the cases. We know this because of case studies like the one that I'm going to talk about in a minute involving the renegotiation between AIG and Goldman Sachs. And we kind of know it as a matter of economic theory because the cost of writing truly complete state contingent contracts can be extremely high. This includes both sort of the upfront costs of actually determining what all the different states of the world are, and then writing contracts that actually allocate risk and dictate payoffs in each of those potential states. There's also the cost from a contractual perspective ex post of actually enforcing our complete contracts in the event that we're able to write them. So it's not surprising that our contracts are incomplete given all these costs, but that has important implications in terms of how derivatives work during bad times. The risks that this creates, economic sort of, the economic theory of contracting sort of identify are one that we could get suboptimal outcomes. So we'll either not say what the parties are supposed to do or how risk is supposed to be allocated in a given state of the world, or two, we might open ourselves up to opportunism. So if everybody's equal in this state of the world where we don't know how we should act because the contract doesn't specify it, it may be the case that we're just incentivized to renegotiate. But where there are asymmetries of information or bargaining power, we might think that one of the counterparties might use that in order to renegotiate the contract in a way that enables it to extract value from its counterparty. Thankfully, the same economic theory of contracting literature that identifies these problems also identifies sort of broadly the classes of solutions that we might find. So we see the use of property rights. So rather than contract, we can just allocate property rights. The key benefit of property rights in this case is it effectively enables self-executing enforcement. I don't need to enforce my contract. I own it. I have the ability to do with it whatever I want. The second is the allocation of decision-making rights. So if my contract's incomplete and a state of the world arises that exposes that incompleteness, the allocation of decision-making rights enables one party to actually say what needs to be done. We get clarity by virtue of the fact that one of the parties now clearly has decision-making authority. Now, there's obviously some really thorny questions here that I won't fully have a chance to address today. Namely, how do you allocate decision rights to the best party in the circumstance of that incompleteness? How do I tell ex ante who should get authority ex post? And there are huge issues surrounding that that make this a very difficult type of strategy to implement successfully, and one that, when we come to the AIG Goldman Sachs story in a minute, we'll see was not particularly done all that successfully. And then lastly, we have standards-based contracting. So rather than dictate specific terms, we can identify standards that a party is required to meet in the course of dealing with whatever uncertainty, whatever incomplete contracting exists. Derivatives contracts evidence all three of these things, just very quickly. So property rights, well, we allocate collateral to counterparties with larger exposures. So both initial and variation margin can be viewed as, in effect, shifting property rights in the event that the exposure of a counterparty becomes heightened as a result of changes in market or counterparty credit risk. As we'll come on to in a moment, there are decision-making rights. Most importantly in this case, the use of something called a valuation agent designed to calculate the applicable collateral requirements. And then lastly, we have a whole host of standards-based contracting. enough to keep commercial litigators in business in perpetuity. We see this in circumstances where we might expect to see it, to be honest. So we see it where the valuation agent, typically the dealer in a transaction, is given authority to calculate margin requirements, where they're required to act in good faith and in accordance with standard market practice. Why? Well, because being a valuation agent, especially if we can't observe market prices, comes with a lot of power. And in this particular case, using standards-based contracting provides, at least in theory, some sort of check on the exercise of that power. Namely, it has to be exercised in the standards of good faith and in accordance with standard market practice. We also see it in payments, where we see things being made in customary manner. For those of you who are payment systems geeks, which probably only includes me, the rate of change in payment systems and settlement systems is so fast that to dictate in detailed terms how payments should be settled is to just ask for trouble. So customary manner covers all different types of mechanisms that you might get. They vary across jurisdiction, they vary across time, they vary across different types of derivatives products. So given that heterogeneity, it makes sense that we see standardization of this term around customary manner of payment. Lastly, and for those of you, and I think there's quite a few of you here today taking principles of financial regulation, we see standards-based contracting in relation to compliance with regulatory requirements. Regulation of derivatives and their counterparties moves so fast that having somebody maintain authorizations across a detailed list of different types of regulations would be suboptimal, certainly very hard even to keep up with. And so having a more general standards-based term that says that they have to maintain reasonable efforts to maintain all government authorizations makes a lot of sense. Kind of basic contracting stuff, but nice to see it actually play out, the theory play out in the context of derivatives markets. Lastly, here's where I'm either going off the deep end or perhaps saying something new, is that even after all of those mechanisms, there's still something left. So collateral, it's quite expensive. Valuing financial assets using the valuation agent mechanism, it's actually quite a subjective process and one where identifying true price, especially with more esoteric, less liquid instruments, is actually something that's not undisputed. And of course, when it comes to standards-based contracting, you've got to go to court to enforce them. So there's this role then, given the costs associated with these mechanisms, for relationships to play a meaningful role in the context of derivatives contracts, at least in theory. And what I'm going to talk about next is that theory in practice. For those that may not be familiar, I am drawing a distinction here between two types of relational mechanism. One between the expectation of future dealings, which is that Horst and I expect to do business in the future, and how Horst behaves towards me will dictate my behavior towards Horst. And the other one is reputation. So how Horst behaves towards all of you will influence how I behave towards Horst. And this is going to be important to understand how Goldman Sachs saw its relationship with AIG versus its broader relationship with the marketplace. Okie dokie. So to illustrate this relational dimension of derivatives contracts, I've gone back to really a treasure trove of information released by the Financial Crisis Inquiry Commission that included a large volume of email correspondence between AIG and Goldman Sachs in relation to its, about 35, I think, or so derivatives contracts on multi-sector CDOs. So these were credit default swap contracts where AIG was effectively offering credit insurance against defaults under various CDOs linked to the subprime mortgage market. And we have really a large volume of correspondence that takes us from the period where we start to see distress in the subprime market through to the period and after the period where AIG received support from the federal government in September 2008. So the basic idea of these agreements was that AIG provided credit protection in exchange for which Goldman Sachs paid AIG a periodic fee. We also have some of the more detailed elements of these contracts thanks to the FCIC. So there were 3 collateral triggers in the AIG Goldman Sachs contracts. So these were events which would require AIG to post collateral to Goldman Sachs. The first one was that there was a change in the CDO's credit rating. So if the credit rating was notched down, that would trigger collateral, the requirement to post collateral. If the CDO's price went down by 4% or more, that would require AIG to post collateral. And if AIG's own credit rating was downgraded, that would require AIG to post collateral. This created quite a pro-cyclical dynamic. There's quite a bit of writing on this. We can talk about it a little later on. This part of the market has changed dramatically in the wake of the financial crisis, precisely because of this exact case study. Interestingly, the valuation agent mechanism in the case of the AIG Goldman Sachs contracts was that both parties were the valuation agent. I've never in my life seen that before, and it may, to a certain extent, explain what happened next. I'm not entirely clear of that. I've talked to AIG's general counsel from that period about this, who hadn't noticed this aspect of the contracts. It's strange that you would allocate decision-making authority to both parties, because that's kind of like having a joint venture agreement where you have a 50-50 interest, and as soon as there is a dispute, you just get deadlock. In this particular case, we also see a threshold amount. So the amount of collateral that had to be posted had to exceed, or the loss, sorry, had to exceed 75 million before AIG would be required to post collateral. And importantly, at least the agreement said that once that's triggered, AIG has to post collateral within 2 business days. Effectively 36 hours, but in effect 2 business days. And then lastly, if there was dispute under this agreement, specifically as it related to the pricing of the contracts or collateral, this had to go to a dealer pool. This is a pretty common provision. It basically says that if the valuation agent has given a mark on collateral or the price of the contract that the other counterparty disagrees with, the dealer has to go out to the marketplace and solicit 4 or 5 other dealer quotes, and that the arithmetic average of those dealer quotes becomes then the price that's relevant for making the calculations under the contract. This is going to be quite important in a moment. All right, then, so obviously most of us, if not all of us, know the story of what happened next. What happened in the subprime mortgage market certainly didn't stay in the subprime mortgage market. And we see the triggering successively of each of the requirements under the credit support agreement for AIG to post collateral. And on July 27, 2007, we see Goldman request $1.8 billion worth of collateral from AIG. This is obviously not a small amount. This is a very large amount, especially for firms that are engaged in putting capital to use rather than having it sit on their balance sheets for the purposes of, for example, paying out variation margin requirements. By September 2008, that 1.8 number will be increased to about 9 billion, making it, I think, pretty far and away the largest collateral call in the history of the world. So we're talking huge amounts here. Now, the interesting thing from my perspective, I think, is what happened next. So what happened after the $1.8 billion collateral call in July 2007? On the surface of it, it was a renegotiation. AIG didn't pay this amount. It ultimately paid incremental amounts toward a full amount. Ultimately, I think it paid about 6.5 billion, but significantly later, months later, not the 48 hours that it notionally had under the contract. And there could be several reasons for this. The first and most famous one is that there was a lot of uncertainty and disagreement about the price of the CDOs. So if the collateral requirements were linked to the value of the CDOs, then the value of the CDOs, if it's not observable in the marketplace, becomes something that's a point of contestation. And that's exactly what we see. While Goldman was able to mark several of the CDOs to market, some of them it had to use its own internal valuations for, and it was those internal valuations, in effect, that AIG was contesting in its own unique way, as we'll come to see, as inaccurate. As it turns out, AIG was not doing its own calculations to compare against Goldman Sachs. So it looks like those objections were just, well, we don't like this. Try again. AIG, meanwhile, saw Goldman as a business partner. And the head of AIG's financial products unit, the unit that had entered into the CDS with Goldman Sachs, makes repeated references to the fact that, hey, no, we do a lot of business with Goldman Sachs, and we don't want to just tell them to go away. We want this relationship to continue, and pressed this to his subordinates that they needed to manage this relationship with Goldman Sachs. For its part, Goldman Sachs also thought that enforcing these collateral requirements could be embarrassing for the firm. Why? Once you enforce them, this information leaks out into the marketplace and exposes one of two things, if not both. The first is that somebody thinks that you don't know what you're doing in terms of the valuation of the underlying CDOs, which to a firm like Goldman Sachs has clear reputational implications as a market leader. The second thing is that rule number one at Goldman is that the client always comes first. Bankrupting your client because you wanted to get your collateral back sort of chafes at that notion in a very sort of obvious way. And so we see one of the senior Goldman Sachs structured products guys writing a memo to the board of directors saying, look, you want to be really careful with how you communicate this to both AIG, but how you communicate any details about this dispute to the marketplace, because any details that make it out can only say bad things about Goldman Sachs as a firm. Lastly, we see, oh, sorry, yeah. Yeah, go for it.
So I don't know whether this is an alternative hypothesis or this is part of what you're saying. But when you're dealing with a solvency event like this, then managing the future relationship seems sort of, it's obviated by the fact that the counterparty is going belly up. So and part of Goldman's strategy here at this time period was its relationship with the government, and using the government in some sense to be the counterparty, right?
Yep.
For in the context of the AIG bailout. So when AIG says Goldman is a business partner and needs to manage the relationship, that makes complete sense because these people are coming to take $2 billion and we're saying, oh gosh, we need to manage the relationship.
Yep.
For nothing, just if not for anything, just so that they don't go belly up sooner than they'd like to. And from Goldman's perspective, it might just simply be a case of saying, well, we've got actually a much smoother way to collect on this, right? And so it's not really managing the future relationship as much as I need to make sure that there are some suckers in the market to buy the crap that we're selling.
Yeah.
And as long, so is that the same story or is it a different story?
So, and I completely agree with, there's several added elements to this that make it strange. Well, not strange, entirely predictable and make for a messy signal, a messy relational story here, right? So as I'll talk about in a minute, Goldman Sachs also started taking out CDS on AIG. So it was actively trying to mitigate its counterparty credit risk to AIG, or what in effect at that point was the risk that the collateral would ever be delivered. I think this story is also consistent with the idea that they were trying to milk AIG for as much of the collateral as they could before they let it fail, right? Because they knew that AIG had a liquidity constraint, and as long as it kept its foot on their throat, it could let AIG sort of liquidate as much collateral as it could. Because of the carve-outs from the automatic stay and fraudulent preference rules, it could theoretically extract more from what is about to be an insolvent estate. And it is also consistent, although I think my personal view, and I know evidence to support this, my personal view is that it probably wasn't Goldman Sachs' strategy. Oh, AIG will get bailed out, and we'll get the benefits of that bailout, which is ultimately what happened. But it's consistent with that story as well, absolutely. So yeah, and what I also want to take away from this is not the pure relational story that aren't relationships great, but that this story is actually idiosyncratic to this particular relationship. And that because this is idiosyncratic, it could be idiosyncratic in another case. And in fact, AIG was also entering into parallel negotiations with Société Générale at the same time that went along entirely different dynamics. Why? Because SocGen was not Goldman Sachs. The exposures were significantly smaller, and SocGen had taken the sort of not unreasonable position that it was going to wait to see what Goldman Sachs did before settling anything. Yep.
So Dan, your point is idiosyncratic. I mean, I'm thinking about the Icelandic banks because Goldman and others didn't seem to have any hesitation in making collateral calls there.
Yeah.
Which banks then failed. And so, what can we learn? What can we generalize from these idiosyncratic examples?
From a policy perspective, or just in terms of describing the marketplace?
Understanding what the determinants of the relational behavior might be.
Well, I think so. We can actually might as well get onto it now.
Just one follow up on the point, because I don't think that the stories are consistent. Because if Goldman Sachs really calculates with the government bailout, they have to appear as pretty harsh in order to push the AIG at the brink of insolvency in order to make it credible that there's a need for bailout. Because if the government realizes, well, these guys are not so tough on this firm anyway, so they might back away. So I think there is an inherent tension in the stories.
There's a dissonance there, though, right? So I'm talking about the relationship between AIG and Goldman Sachs, the executives in a room talking, as subsequently documented by both the Ben Cohen book and then the FCIC material. Goldman Sachs was very good at making sure that it sent its collateral call every day, right? From a formal legal perspective, it was lining up the future litigation perfectly. Every day, new collateral call, updated on their current marks, that then made them look tough, right? They didn't, so the formal documentation that you would ultimately expect to be submitted in court was definitely the tough stand. What made it interesting was I got access, well, we all have access, thank you FCIC, to this other conversation that was going on. And we also don't see, right, that these statements were made internally at Goldman Sachs and internally at AIG. I wouldn't let my mother read some of the correspondence between AIG and Goldman Sachs. That was much more unsavory, I suppose. But I agree with your point that I think that there is that tension there in that element of the story, for sure. Oh yeah, we were going to go ahead to this. So, and I'm just going to put a pin in it for 1 second so we can get through there. Just to say that, so what do relationships potentially do here? Well, one, in a world where contracts are incomplete, they can give us some flexibility. I've put this sort of 3 different ways. You can have flexibility. This can be a safety valve against contractual rigidity. If AIG had to post collateral within 48 hours, it would have failed a year earlier. Is that a good thing or a bad thing? I'm not making any judgments there. Or alternatively, from a more finance perspective, what the flexibility does is provide one party with optionality, effectively, to not adhere to strict enforcement of the contract. And that can have pretty valuable benefits. I've also, for those that enjoy sort of the more legal elements of contracting, made a couple of points here that things like valuation agents can be useful insofar as they give the parties an opportunity to signal that they're being cooperative or not cooperative in the context of a relationship, enabling the parties to learn about what type the other counterparty is, cooperative or not cooperative. And it's sort of consistent with the braiding hypothesis of Gilson, Sable, and Scott, that if we know that contractual rigidity can bind our hands when we enter into these contracts, it may be useful to also have these escape valves in the contract that then say, okay, well, when things are really bad, reputational constraints will enable us to inject some flexibility into this contract. But back to the question. So John's question about what's generalizable here. And let me know if you think that I'm not answering this question. I think the first thing is that this case study shows, as you'd expect from reputational mechanisms, that the bigger the relationship, the more flexibility you're likely to see when everything hits the fan. So if you are a small counterparty with Goldman Sachs, you're unlikely to see that flexibility. And certainly as a, somebody who comes from the asset management side of things and would do deals with Goldman Sachs, I never saw any of this flexibility. If you objected to anything in the ISDA master agreement, they didn't return your calls for 3 months, and everybody was breathing down your neck. So the AIG story is not one that I necessarily saw when I was on the other side of the table. So the size of the relationship could be important. And this, in terms of general things to take away, may complicate the matter more than simplify it, is that in derivatives markets, there's a lot of mechanisms that then create countervailing incentives. So this relational world doesn't, or is going to be less important the more the counterparties are collateralized. Or in the case of Goldman Sachs, where one of the counterparties has taken out insurance against the failure of the other counterparty. In those worlds where the loss experienced by one counterparty as a result of the failure of the other is going to be lessened, we would also expect relational mechanisms to play less of a role. It's also important here that there can be cross purposes. I think this is one of the more important elements of this. So if the relationship was what was making Goldman Sachs and AIG negotiate, Goldman Sachs was also up against the fact that it had relationships with other counterparties, with other market participants that it wanted to take into consideration as well. So we see AIG very early on say, let's go to a dealer pool. And then for the next year, Goldman Sachs basically resists that, even though it's in the contract, saying we don't want to go to a dealer pool. Why? Well, the internal correspondence makes it clear. We don't want to go into the marketplace and say, Goldman Sachs does not know how to value these assets, please help. That sends a negative signal, damages the reputation of Goldman Sachs in the marketplace. And so understandably, they spent quite a lot of time resisting that. So in effect, their relationship with AIG in a bilateral context had an additional degree of inflexibility because Goldman Sachs was worried about its relationships with other counterparties, other market participants. The last thing is, and this sort of stands to reason, or so one of the last things is, and this stands to reason, is that when the parties don't have equal standing, the relational aspects may not prevent opportunism, or in AIG's case, may not prevent them from biting off their nose to spite their face. As it turns out, Goldman Sachs had pretty robust methodologies for valuing these CDOs. So even if there wasn't a market price, they had a defensible way of putting a value on these things. AIG objected to that, but in congressional testimony, it ultimately became clear that Frank Cassano never even attempted to come up with a valuation model for these CDOs. So given Goldman Sachs' role as a market-making dealer, given its at least attempt to value these assets, any negotiation over their value against a counterparty who either didn't have the expertise or inclination to do so was likely not to be one of pure arm's length negotiation where the relational mechanisms enabled the parties to avoid situations where one took advantage of the other. And lastly, and again, I think this is fairly straightforward, once it became clear, or once it became relatively clear that one of the parties was going bankrupt, or may go bankrupt, subject to this specter of state support, relational mechanisms go out the window. A lot of Carillion subcontractors are learning this lesson as we speak right now, right? All of the attempts since last October, I guess, or even further, in order to save the firm mean nothing once you go into compulsory liquidation, except, of course, when the government intervenes to bail you out. So I don't know if that answers your question, John, in the sense of what's generalizable. I kind of see the top level generalization being that there are no generalizations. And then the second level, I guess, gives you some predictors of when you'd expect to see relations dominate. So when the numbers are big, so when you could lose a lot of money relative to a small amount of money, when things like collateral have not been provided, thereby exposing counterparties to the full sort of exposure to losses, where we don't see these cross-cutting mechanisms like the dealer pool, and where we don't see these asymmetries of information and bargaining power. And so I'll come to it, there we are actually. So what I'd expect to see is, and I make no representations about the accuracy of this arc, but the shape is supposed to signify the idea that when there's no changes or changes are observable, most of the time the contract can do all the work. We just look at the world, we look at the contract says we're supposed to do in that world, and we execute it. We have a property rights system and a contract enforcement system in the background that enables us to affect those changes, but this is contract as blueprint, as instruction manual for how the relationship is supposed to work. As things get more complex, as things get less observable, we would see some sort of increase into the relational world. That is to say, and it may not be big, it may be very small and incremental, where we work out on a relational basis what we want the contract to do going forward. And that, to a certain point, will get bigger and bigger as the problems get bigger and bigger. But then as we start to think about insolvency and we start to think that this relationship may not have a future, we should see this drop rather dramatically. And again, I'm not saying anything about the shape of this particular curve, just the general direction of travel that we might see in these markets. Yep.
Now, you're working on the basis of the assumption that there is a bankruptcy carve-out for all of these things.
I am, yes.
Okay. Now, how would this curve change were there no bankruptcy carve-out?
Well, so I think that's a really interesting question. I think what we would have is, well, I suppose, trying to think about how we would want to consider it in shape. I think we'd probably see the last part of the curve move farther to the left, right? Just recognizing the fact that all of a sudden bankruptcy becomes a strict failure. So and knowing that, you'd probably see a lower slope of the curve on the left-hand side because you wouldn't be willing to take as much risk, as much exposure to the firm. So assuming this is accurate for a second, I would think that you would just shift it farther to the left and reduce the slope of the left-hand side of the curve. So they would make less relational investment ex ante, and they'd be sooner in pulling that relationship back in when the specter of insolvency started to rear its head. Would be my first intuition on that. All right, so what does all of this mean? And I want to open this up for discussion, if for no other reason than I can eat my sandwich. The paper goes into more detail about this. One of the horses I've been beating for a very long time is that derivatives should not be treated as securities. The paradigm of market or information forcing regulation to force market transparency, while perfectly consistent with the idea of deep liquid markets in good times, is really inconsistent with the other half of this story where all of a sudden I've got debt contracts that include elements of property and relationships. This looks like a commercial loan that's been collateralized, not like a publicly traded share or a bond. And this is more than simply a categorical issue, right? The last time that we allowed a securities regulator oversight of a prudential issue was the Consolidated Supervised Entities Program of the SEC, enabling the SEC to oversee the capital calculations of the major investment banks. That was an unmitigated disaster, and understandably so. They're market regulators. Their objective is to force information and enable the market to make decisions about things. Prudential regulation, the regulation of loans, counterparty credit risk, is all about private information that is analyzed and then decisions are made by prudential regulators about how to manage that risk. Two completely different paradigms, and one that then means that we can't get caught up in the institutional path dependency of banks do banking, securities are markets. Most modern financial systems are hybrids, and derivatives in that respect are just an example of this. The other three policy implications that I talk about in the paper all come down to this question of whether the flexibility injected by the relational mechanisms is a good thing or a bad thing. And for those that read the paper, you'll see that my answer is both, depending on what stage of the relationship we're actually at. So in terms of central clearing basically takes out the relational elements, right? So we have entirely standardized contracts. We have automated rules about the collection of collateral. So for example, but for a couple of mechanisms I'll talk about in a second, a clearinghouse doesn't have the ability to say, okay, AIG, you look like you're going to fail, so I'm not going to collect collateral from you today. They can't do that. The rules have bound their hands to a system where you see both a high degree of credible commitment because the rules are so binding, but also potential contractual rigidity. One of the things that's not appreciated entirely about these clearinghouses is that there are mechanisms designed to alleviate this contractual rigidity. And the two that I talk about in the paper are things called partial or complete tear-up procedures, which as the name implies, enables you to tear up contracts. And then variation margin haircut gains, which effectively enable you to accept collateral from counterparties that are out of the money, but not pass it on to the counterparties that are in the money, thereby enabling you as the clearinghouse to fortify your own balance sheet in the middle of market distress. Now, that in turn raises some questions about the governance of clearinghouses and who you want to have control over this flexibility. And as I talk a little bit about in the paper, but isn't fully developed right now, who you want controlling those decisions depends on the governance model of the clearinghouse. So is it owned by members, or is it owned by another sort of independent firm, like a stock exchange or independent third-party investors? If the former, well, then you have one set of incentives when it comes to exercising these mechanisms. If the latter, and they're sort of third parties and detached from this, one might think that their incentive is actually to download as much risk as possible onto the clearing members, in which case there may be conflicts of interest between the survival of clearing members and the survival of the clearinghouse. And in that case, it may be useful then to allocate that discretion to prudential supervisors as opposed to the clearinghouse itself. It wouldn't be a paper these days if it didn't have some blockchain component to it. It probably doesn't surprise you to know that the International Swaps and Derivatives Association has doubled down on using distributed ledger technology to even further automate clearing and settlement within derivatives markets. And again, this makes a lot of sense given the state contingent nature of a lot of the contract features, but also presents potential contractual rigidity. That is to say that if I have these systems where I automate, in effect, things like variation margin requirements, things like variation margin haircut gains, that if those rules aren't complete, if they don't entirely automate every potential response to every future state of the world, we may end up in states where we end up with what's called wrong way risk, where we end up enforcing things like collateral requirements in ways that undermine the integrity of the system. So they cause a clearing member to fail, and the reallocation of losses amongst surviving clearing members causes the clearinghouse to fail, which then has feedback effects to the surviving clearing members. This has happened in the past and could happen again. Again, the key then is coming up with similar mechanisms, safety valves that are designed then to alleviate the pressures of contractual rigidity in those circumstances. And there's a couple of computer scientists at Cornell who have developed a protocol for a permission distributed ledger system that then says basically, okay, we can press the stop button. No transactions go through, but we crystallize at that moment in time what the obligations are. And then when whatever crisis has passed, when we have more information, we have two choices. We can press play, in which case the performance at that given moment in time is then executed, or we can amend performance given new information that we now have in the marketplace. So we inject some judgment, some human judgment back into what would otherwise be an entirely automated system. Lastly, and I think I'll just mention this very briefly, we don't have a great conceptual basis at this point for understanding why we do things like support markets during periods of market turmoil. So there was 13 or 14 different initiatives that the Federal Reserve in the United States took to support markets during the financial crisis. Not financial institutions, but to support very specific markets. The asset-backed commercial paper market, the ABS market, derivatives markets. And I think understanding these contracts as having a relational element that then, if it works during good times, breaks down during bad times, gives us a sense of what the state's role is in that circumstance. Where the trust breaks down, the role of the state then, as the counterparty that can't default, is to stand behind contracts, put in a market floor. That raises a lot of interesting institutional questions about how you do that without creating moral hazard, without having people game the system. But it at least provides a theoretical basis for understanding what the problem is and then providing some sort of justification for addressing that market failure. Sorry to drone on so long about that. Questions? Yep.
Sorry, I'm Simon Leeson from different charts and results. Just a couple of observations about the AIG collateral position, because I think it is right. The big learning from all of this is that collateral requirements are capable of bringing down financial systems. What was going on in the CDS market at the time was a run. But the interesting thing about the position that Goldman was in was that it is very useful to think about a CDS as an insurance policy. If you've got the benefit of an insurance policy and you call a lot of collateral under that policy, unless the insured event's concerned, you're going to have to give it all back again. This wasn't a matter of Goldman saying, we want this money so that we can keep it. They were saying, we want this money as a sort of earnest against your not paying claims in the future. And if calling that collateral caused the collapse of the insurance company, then you were in a disastrous position because you had to hand the money back. You'd lost the benefit of your insurance, and as far as your risk position was concerned, it had just got 100 times worse. So I think it's a very useful demonstration of the fact that as soon as you get into the weird world of collateral, you have to start thinking in a very different way from the way that you think about payments. And in the context of credit derivatives particularly, it's almost two different ways of analysing the same contract.
Yeah, I think that's right. I think there's in the case of AIG, there's also the basic financial economics of insurance that comes into it, where AIG was underwriting the insurance of a large part of this market. And if insurance had to be paid out for these events, it was going to be highly correlated, in which case the insurance company fails, which is just sort of a vindication of the idea that you can't insure against systemic risk, which came out in space. I should say there's a great paper in the Harvard Law Review by Richard Squire at Fordham, who says that AIG understood this perfectly, and was actually on the other side of this market in the securities lending market as well, because it knew that if it, either heads I win or tails you lose. If the market survives, I make money on both sides of the table. If the market fails, I'm done anyway. And it's somebody else's problem if you can't get your payouts from me. Tough luck. So that the I'm dead, you're dead scenario. So yeah, I think it's at sort of the intermediate and higher levels, that's the exact way to look at it, yeah.
Maybe just as a follow-up on that one, because I think that the way you frame the problem as a case study, I think that somehow loses the systemic dimension, which I think is at play here, because most of the incentives, relational or not, probably are also motivated by the idea that, like you said, this is going to kill the market anyway, and then I think you're probably even more willing to somehow be lenient on your partner in a contractual relationship. I think that is something that beyond the sheer size of the contractual relationship that they have, it's also the market aspect here.
I agree. It bugs me about the case study as well. This idea sort of sat for a really long time until I came across the FCIC material. But I think to fully deal with the implications, I need more material on what market participants were actually doing and thinking at that time. The problem is coming up with some sort of toehold to be able to say, I think, exactly that there is this added dimension of systemic instability. And of course, then that would enable me to be much more robust in my discussion down here of what the dynamics actually are in that context. I agree with you, absolutely. Yeah.
I was wondering, in case, so you made the argument that in case the counterparty goes bankrupt, those informal mechanisms sort of go bust as well. But I was wondering to what extent reputation still has a role to play, because it's about what third parties think about your behavior.
No, so that's a fascinating question, right? So if I'm the administrator of a bankrupt, if AIG had gone bankrupt, and it looks at what a financial institution is, right? It's its reputation. Charter value is everything in financial services. So if I just liquidate, in effect, or if I start cherry-picking contracts that I'm going to honor versus those that I'm not going to in bankruptcy, that can have a knock-on impact in terms of the viability and value of the entity that leaves bankruptcy subsequently. Now that's complicated by a few things, right? How much is firm reputation versus individual reputation? But I think you're absolutely right that there's reason to believe that, especially for financial services firms, and any firm where the assets are primarily intangible, there will be something that survives bankruptcy in the relational sense. In fact, that may be another, there's not bankruptcy scholars in the room, that may be something that I need to talk to them about, because I think that intuition makes sense. Yeah. Which is also, admittedly, I didn't do it for the precise reasons that you've mentioned, but that's part of why this isn't a straight line, right? Because if the relational story died at bankruptcy, then I would just have a point here that was bankruptcy, and then it went straight to the horizontal axis. So yeah, now I actually have a reason for drawing the line as I've done. More questions? Okay.
You told us already that others have pushed you on the differences between derivatives and bonds, and for sure, with the bond you can sell it, and there is no such distinction between counterparty risk and market risk. But in terms of contractual governance of the bond relationship, considering bondholders as a group, and how they now at least can coordinate, like basically selling to some specialized bondholders who will be like active owners. What is the difference from this point of view?
I think the difference there would be that that story requires on a specialized intermediary acquiring the bonds, right? So the parts of it that make it look similar are then because a specific intermediary acquires a threshold amount of a specific type of claim, if I understand you, as opposed to the instrument itself. Does that answer your question?
Yeah, but it's something. People who buy the instrument know that in case of crisis, there will be instruments to deal with the uncertainty and the problems you're having in the bad times.
So, are you mean like bond agents or collective action clauses, things like that?
And the fact that there is a market where these interests can be aggregated, and the sort of negotiations that go on.
But you can't negotiate. So, I mean, my starting point for that is that you can't negotiate the terms of a bond in the secondary market, right? It is what it is. You can create a derivative that then divides it up, but you've just created a derivative to do that. Whereas derivatives, because these are executory debt contracts, right? Because we've actually got an individual counterparty who may have entirely uncorrelated payoff patterns to the actual underlying that creates the difference here. So there's an idiosyncratic nature to it that just I can't see existing in a more commoditized product. So if I want, and the longer answer is, so if the alternative version was right, and that bonds are derivatives and derivatives are bonds, why would I have a derivative, right? And putting aside that maybe my bond market is incredibly illiquid, the idea is that they're economically equivalent. And they're not, and I know this because I can enter into a derivative on a bond that gives me a very different portfolio of risks, primarily counterparty credit risk, which doesn't exist in the bond, even though my payment structure under derivative can be identical in terms of just linking it to the current market price of the bond and recreating the cash flows associated with any coupon payments. So I've created a new risk by using derivatives there, and that new risk, counterparty credit risk, in most states of the world, ideally should be uncorrelated. And it's that uncorrelated counterparty credit risk that I find to be a different thing. And it just so happens that 95% of the contract is dedicated to what do we do with that uncorrelated counterparty credit risk. Does that make sense?
Yeah, but still I think with a bond, in bad times, you will have a situation very similar in which you can either go into bankruptcy or not, but you often don't go because you know that you are worse off.
So you as the issuer there, though, right?
You, the bondholders at the issuer, will negotiate and find solutions that are not what the contract says.
Oh yeah, that element is the same, save that for a marketable security, you're unlikely to have unilateral power of renegotiation. And because you don't have unilateral power to renegotiate, any relational mechanism will be lessened because your relationship is necessarily less important. Another way to put this, in which case I would totally agree with you, is as you get more concentrated holdings in any security, there's likely to be more relational mechanisms. And, that's acknowledged in corporate finance literature and acknowledged in the rules around things like, controlling shareholder laws. And that I would totally agree with. And it's on a spectrum, right? So a derivative contract gives you that from day one because it's a bilateral contract between you. Completely atomized dispersed markets where I'm a price taker. If I was a price taker in the market, I'm probably a price taker in any renegotiation. As I gain more control, though, I can use that control for the purposes of influencing outside of the bounds of the contract, that is relationally, on the issuer of those securities. And that I totally agree with, yeah. Yep.
I was wondering to what extent you think the idea of having a government act as a dealer of last resort is a feasible one, because that would sort of assume that the government can value the assets, while it's often just a bit like in the AIG and Goldman Sachs case study. AIG didn't really know how to do it, and I was wondering to what extent the government would be able to do that in bad times.
That's a very nice point. I think the first question becomes identifying which markets you actually want to support. And to me, the first answer to that question is the interest rate swap market. The interest rate swap market is largely dictated by macroeconomic policy issues around short-term versus long-term interest rates and expectations of productivity and growth. That's exactly what central bank macroeconomics departments do for a living. Aside from that, guess who the primary players are in that market already? It's the government, right? Open market operations are entirely about understanding the yield curve and pricing within those markets. So that lines up fairly well, but that's the easy case. From there, and sorry to ease and talk at the same time, I'm likely to keel over. From there, we have to sort of, well, what are the other markets we want to really support? I mean, really support. Do we want to be in esoteric commodity futures markets? Well, maybe not. Do we want to be in equity derivatives markets? Probably not. Do we want to be in single name CDS markets? Probably not. Both because, absent other factors, they shouldn't be systemically important, but also, and I agree with you, that we wouldn't expect the state to have any additional expertise over the markets within those markets. Now, the interesting one that leaves is actually the foreign exchange market. And I can't get my head around this one. Both because, in this, we're talking about the deepest market in the world, right? There are more transactions done in the foreign exchange market per day than, well, every 20 days, the foreign exchange market does more volume than all of the world's equity markets in a year. It has never experienced the type of fundamental illiquidity that we've experienced in the financial crisis. Spreads widen quite a bit, but we haven't had the experience yet where market-making dealers actually leave so that you can't get a price. Now, that's not to say it can't happen, because it can. But I think it's a special case study for lots of reasons. Partially because money and FX is the most informationally insensitive asset you could possibly imagine. So it's not like market participants can look at the government of the United States and say, I know where the US dollar is going to be in 5 years. I mean, lots of people make a good living at trying to do that. But it's difficult to come up with a rationale for why they'd be better doing it than the government themselves. So the short answer to my long answer, interest rate swap markets, I think that both the incentives and expertise line up quite well. A lot of other derivatives markets, so especially equity, CDS, and commodity futures markets, not systemically important. I probably wouldn't advocate them intervening. And the one I've got to think about is FX markets, where they're big, they're important, but historically we haven't seen them break down in the same way that we've seen others break down.
I think we've got time for one more question.
I think I missed one over here earlier, actually. You've got...
Sorry,
yes.
just on the idea about bad times and when the non-observable changes are from market risk as opposed to counterparty credit risk. I know that they can kind of correlate, but they're also very separate things. Do you have any ideas about how those relational mechanisms would play out due to different risks? Like I was thinking with AIG, was it the first call was based on the downgrading the underlying?
Downgrading the credit rating of the underlying, yeah.
So that's a market risk, which can then lead to credit party risk. But are they always kind of interplay, or is there some kind of initial intuition you have? Or
I have been lobbying the Office of Financial Research in the United States and the Bank of England here in the UK to start collecting that data for quite a long time. I can't stress enough how the FCIC sort of report on this one contract represents what academics know about what these triggers look like. The International Responsible Derivatives Association has definitely said to market participants, look, these pro-cyclical triggers, get them out of your contracts. But we don't have anything that tells us whether they've been removed, and if so, what they've been replaced with. So
and
we don't
you
have
can't do the
anything.
next step in the analysis as to
Exactly.
how
Yeah. So, a beautiful research question. Maybe one day the Bank of England will accede to my request, and we'll be able to look at the evolution of the market, if there has been one, from the lessons of the crisis to where we are now, whether it's better, worse, or indifferent.
Okay.
Wonderful.
Yeah, I just wanted to come back to Luca's question and your answer to it, because you said in the bond market there is a spectrum, and some market participants, they might have the power to renegotiate any contracts, and others don't have this power. But isn't it the same in the derivatives market? Because you said earlier that many market participants don't have the power to call Goldman Sachs and to say, okay, let's talk about this on this clause in the Istanbul Agreement, and so there's also a spectrum.
So, but it's a different spectrum, right? So if I enter into a derivative contract with Horst, and I enter into a derivative contract with Goldman Sachs, chances are the relational dynamic between Horst and I will be bigger, right? It'll always be different because Goldman Sachs is different than Horst, marginally, but different. In a bond market, both Horst or I or Goldman Sachs, if we went out and bought enough of the bonds, could exert relational sort of dynamics on this situation. So and that's the difference, right? In derivatives, it's about the security or the instrument. The instrument confers possibility for relationships. In the case of bonds and shares, it's about who holds it, which is a different thing. Also, the fact that there's no debt in there, right? So, in the sense that, not no debt, but in the sense that if I just hold a whole bunch of bonds, I have credit risk, I have market risk, the other side has nothing, right? All there is governance and the threat that I might sell or say that everybody else should sell or something like that. There's no reciprocal exposure that brings the two of them together. Put differently, there's no natural reason why they should have a relationship. Unlike a derivative where the existence of the contract is the reason for is a reason for the existence of the relationship. And I mean, this is not a clean answer to this question at all. And I think that it's, I've been working on this question probably for about 5 years now. This is my second or third paper on it. And these objections are still legitimate objections to this issue. And so we're still drilling it down. But I still think that there's something there. There's a new section of the paper that I'm not sure is in the one that I've circulated that attempts to distill this more cleanly. It does so on the basis of if I'm holding it, what is it to me, right? And if I'm just holding a bond, so if we take the smallest unit of a bond and the smallest unit of a derivative, it seems to me that there is no, and I have no idea what the smallest unit is, right? But a contract and a bond, is that bond is going to have no relational elements to it. How do I know this? I can toss it to somebody else who's willing to pay for it, right? The smallest amount of a derivative contract, I just can't punt it to somebody else. I have to punt it to somebody else who's willing to take the counterparty credit risk, that idiosyncratic risk of my counterparty. So it's incomplete risk transfer in economic terms, and in practical terms, I don't sell it and then forget about it. I sell it and continue to have to worry about it because I still have the original risk, and I've just created a new contract to offload the market risk, but not the counterparty credit risk associated with that contract. And that's the basis of it. Whether it works from a relational perspective, whether a relational dynamic is the best way to characterize that is, I think, even an open question for me, and I'm the one making the argument. Yeah.
Thank you. I think it's time for a closer netting of our derivatives contract, Dan. There's a net payment. There's a net payment, I think, that we owe to you. Thank you very much for showing us the anatomy of derivatives contract.